If someone offered you a check for $5,000 and for $5,000 they ask you to place phone calls and you take their phone and you place phone calls and you place 2 phone calls, you get the $5,000, or you place 20 phone calls and you get the $5,000. Which one are you going to do? Is that what you want to set your attorney up to, the kind of choice you want to set them up for? I sure as heck wouldn't. When you work with a law firm or an attorney, you're going to be asked to sign what's called a retainer, or in our case, we call it an engagement agreement. This is an agreement between you and the law firm, and it spells out a bunch of things, but here are the really important ones you need to pay attention to. The first thing that it spells out is the scope of work. We are going to be representing you for this specific thing. It might be your divorce, your custody case, your domestic violence case, your prenup, whatever it is. It defines the scope of work that's going to be done, and that has to be very clear in an engagement agreement. The next thing is the financial terms. How much is this going to cost? Is there an initial deposit upfront that you have to pay? Are there any additional deposits that you have to pay for trial or depositions or other things? How often is billing done, and how are things billed? The financial terms absolutely need to be laid out. And finally, there's that other stuff, the kind of important things, but they're the terms of engagement. And what I mean by that are things like rules for how you guys are going to communicate, how often you're going to hear about your case, whether or not any outcomes are promised, any responsibility towards appeals, those kinds of things. You want to make sure that you take the time to read the retainer and the engagement agreement so that you understand the relationship between you and the law firm and you and the attorney that you're going to be working with. It's all defined so that everybody is super clear and on the same page.